Ben Leather from the International Service for Human Rights has the floor.
Madam Chair, states are the primary duty bearers in the protection of human rights, but they must do more to ensure a positive contribution by business. Given the capacity of human rights defenders to prevent, mitigate and ensure accountability for human rights abuses, it is crucial that states do more to ensure that business, both at home and abroad, does not threaten a safe and enabling environment for defenders, but rather contribute to and protect it. A treaty should enshrine this obligation. For example, states should regulate the work of private security firms and ensure that adequately trained civilian authorities police protests, rather than private entities. States should also fully investigate and sanction any attack against human rights defenders in order to prevent a climate of impunity. States have a duty to ensure that businesses, plus their subsidiaries and those who they contract, understand what is a safe and enabling environment for human rights defence and how they can contribute to that. When threats against defenders occur, states must implement protective measures, commensurate with the nature of the threat. Some of these measures may require implementation by business and could include, for example, the facilitation of dialogue with an affected community or the suspension of a project if that is where the roots of the threat lie. Madam Chair, ISHR constantly hears testimonies that the roots of human rights violations in the context of business are found in the lack of a free, prior, informed and safe consultation of communities, civil society and human rights defenders. The roots of the threats against those actors are therefore to be found in the same. Consequently, it is vital that states make and implement laws which guarantee the free, prior and informed consultation of communities, which respect traditional decision-making processes. This is a crucial preventative measure which could ensure that the seeds of conflict and the abuses and the risks for human rights defenders do not even begin to grow. Regarding extraterritoriality, Madam Chair, it is clear that states must also ensure that their businesses and investments protect defenders in other countries where they have a presence too. At the outset, we celebrate the existence of guidelines for the protection of human rights defenders, such as those developed by the EU, Norway, Switzerland and the OSCE. These outline how their missions abroad can protect local human rights defenders at risk. However, many of the activists who we work with on the ground have complained that the implementation of these guidelines is often weaker when the defender in question is working on alleged abuses in the context of international investment. There is little evidence of embassies working together with their businesses to ensure the protection of activists. The research of Peace Brigades International around the 10th anniversary of the EU guidelines backs up these affirmations. Third states arguably actually have a greater duty to protect human rights defenders when projects with investment from their country are involved in the context which has provoked the risk. Whether states have guidelines on defenders or not, they must develop policies and implement actions to protect those communities and human rights defenders working on business and human rights, regardless of the commercial interests at stake. These policies and actions must include engaging with businesses on the one hand and host states on the other to ensure that more is done to contribute to a safe and enabling environment, to consult civil society and to work institutionally to avoid the root causes of a conflict. This preventative approach is currently often lacking. To sum up then, a treaty must be clear on the obligation of states to encourage actions by business at home and abroad to not interfere with, but to rather contribute to, a safe and enabling environment for human rights defenders, for example through the kinds of initiatives mentioned in this statement. Whilst the treaty process is ongoing, and even once it is concluded, national action plans on business and human rights provide an immediate platform through which states can develop these policies and actions and ensure the protection of these actors whose voice is crucial to avoid, mitigate and remedy the human rights implications of business. Thank you, Madam Chair.
Thank you.